However, the process and so instead of everybody
Aquí también hemos reído.
trying to work against the process,
Necesito solicito es rapidito.
Oh, we're not? Okay, we're live. Hello. Okay, ready?
And now,
We will call
it's
our Senate Standing Committee on Crime Victims, Crime and Corrections to order. I'm Senator Pat Gallivan. We are joined Senators Little, Savino, Akshar, if I can even spell it, and Rivera. And we do have voting sheets from the other members, so we do have a quorum. We have, I believe it's 15 bills on the agenda. The first bill on the agenda is Senate Bill 845. It will be referred to Finance if it passes through the committee, sponsored by Senator Robach, and it has to do with amending the correction law, and it's in relation to establishing a sex offender public awareness program. Motion to report.
Move the bill. Second.
Any negative votes? The bill is referred to Finance. Next, Senate Bill 869, sponsored by Senator Ranzemacher, an act to amend the correction law in relation to knowingly harboring a sex offender who has failed to register or verify. Motion to report.
Move it.
Negative votes. Senator Rivera in the negative. The bill is reported. Next on the agenda, Senate Bill 1085, sponsored by Senator Marshall. This is another bill that will be referred to Finance. It's an act to amend the correction law in relation to requiring legislative approval for the closure of correctional facilities and institutions. Motion to report.
Move the bill.
Any negative votes? Senator Rivera in the negative. The bill is referred to Finance. Next on the agenda, Senate Bill 1474, which also will be referred to Finance, sponsored by Senator Rivera, an act to amend the correction law in relation to establishing a pilot project for the placement of inmates close to home. Motion to report.
I just have a question. We moved this bill last year, Senator.
We did. This bill was reported out of committee, but it did not get reported out of Finance.
In fact, if you read it, it actually is almost like a companion to the previous bill of Senator Marchionne's, which kind of achieves the same goal. We want to keep people, one, to notify localities about the closure of correctional facilities. It's not just good for the employees who work there. It's also for many, if you read her bill, her justification, it talks about family members as well. And yours is as well. One of the problems we have is we downsize the prison system without recognition of the fact that we close them based on population or location as opposed to where the prisoners come from. So, as you know, in New York City, we had the one minimum security facility, the York Hill Correctional Facility in Staten Island. It was where many prisoners were on their way out of the system. And the final place they went to prior to them coming home. The majority of them were New York City residents to begin with. With the closure of Arthur Kill, any future potential prisoners are now placed somewhere else upstate. And so, had we had ample notification of the closure of Arthur Kill, we might have been able to mobilize an argument to prevent the closure of Arthur Kill, to make the very argument that you make, that we should keep people closer to home, to their home community, because it's better for not only the prisoner and their family, but we know from research that for those who are interested in rehabilitation, it helps reduce recidivism. So I support this bill, and I just think that it actually works well with Senator Marchionne's bill. We should look at it as part of a collective. The notification to the community is part and parcel and go close to home issue.
I am a no vote on this bill, and basically, I think that we should look at the prison facilities for what they can do for an inmate, regardless of where they are, what programs they have. And we don't have any more minimum security prisons, which is a shame because they were good for transitioning from prison allowing more FaceTime, things like that, but we don't have no contact. Anyway.
Senator Rich.
Mr. Chairman, I'm a no vote too, Senator Rivera. I applaud you for your intent, but I don't want to lose sight of victims' rights and the families of victims in specific crimes. So, voting on this.
So, comments, Senator Rivera?
Only about that it is a pilot program, and it is, if we look at a correction system in that regard as a system not just meant for punishment but also for corrections, and if we believe that people should, once they've paid their debt to society, be able to move back into society and able to integrate, this would be a way to demonstrate that having an incarcerated person have close contact with their families would make sure that they don't want to go back to prison. So while I certainly respect Senator Asher's view on this, if this is not just about people that are accused of heinous crimes, but folks that are incarcerated, period. And I will repeat, this is only a pilot program meant to inject into the criteria that DOCS uses of where they place an incarcerated person. If somebody is a danger to themselves or others, and they need to be placed in a more high security prison that is 10 or 15 hours away from their families, they can still make that determination. This would be just a pilot program to add the category of whether they have family members, particularly if they have children, in the consideration of where they should be placed in the system, so that they have a closeness to their family. But ultimately, I think we ultimately want people that once they've paid their debt to society, to be able to come back and to reintegrate. So that is the reason why it's a pilot program. We've worked with both Senator Gallivan and DOCS on creating a better bill than it was a couple of years ago. I certainly respect your opinion, but I both thank the chairman for putting on it and thank the folks that have voted for it. Now I just have to convince Senator Young to let it go into the committee.
We are joined by Senator Hassel Thompson, ranking member on this committee. We are on Senator Rivera's bill 147 and everybody is commenting. Would you like to?
I just think my bill's a little better, but I'll teach them how to type.
Never argued otherwise, Senator. Never did.
No. I came in on the tail end, obviously, of his presentation, but in looking at the bill and just trying to understand, I know that there is a prevailing behavior and attitude in this state that's about law and order. And somehow I think we've got to move more toward law and justice. And justice doesn't mean just in the courtroom, but it means going beyond. We want people to be able to come back into communities, and we want their re-entry to be as smooth and as seamless as possible. And a lot of that is predicated on how they are able to retain relationships with families. And I've always advocated it so much more for women than men, but because I've always recognized that men somehow keep connections with families better than women do. Once they go to prison, there's a whole societal piece that sort of disallows them from ever feeling that they belong back in society. So it has been a concern of mine, but I do have an appreciation for the kinds of things that this bill calls for in terms of how we begin to see the possibilities of rehabilitation. And I know that for a lot of people around this table, that's not what people going to jail are about. But I have always been, my entire life, about the rehabilitation, second chance for people. And the second chance doesn't just begin when they come out of prison, but it's when they're in prison. And it's an attitude that they begin to redevelop about who society and what society is.
Thank you. So others have expressed their
I'm voting in favor.
Senator Little without record.
Were you voting against?
Yeah.
I love you.
I will be voting without record as well. If Nico, if you could just read the affirmative votes to see just to see if we are past the threshold.
Gallivan without rec, Little without rec, Mazzolio, aye, Savino, aye, Hassel Thompson, aye, Montgomery, aye, Peralta, aye, Perkins, aye. Rivera, aye.
I'm sorry. You said the Senator Mazzola voted aye on it?
That's what he said, shush, shush.
This bill will be referred to finance, and I would urge the sponsor,
Even the machine was confused for a second.
I would urge the sponsor, and some concerns
Yes.
have been raised, they likely will be finance as well. So I would urge you to try to work with some members who have concern. I don't know if we're able to get past the differences.
I wanted to speak, I wanted to...
Some good points were brought up.
No, absolutely, and I thank you for putting on the agenda today. I will be speaking to Senator Young, and hopefully I have enough time between now and the end of session to see if we need to amend it, or at least getting on the agenda. And then certainly try.
We will move on to Senate Bill 1520, sponsored by Senator Klein. It is an act to amend the executive law and the penal law in relation to prohibiting certain convicted sex offenders from knowingly being within 1,000 feet of any place where pre-kindergarten or kindergarten instruction is provided. This bill did pass the Senate last year.
Second.
Any negative votes? Senator Hassel Thompson in the negative. The bill is reported. Senate Bill 1833, sponsored by Senator Ritchie, will be referred to Finance, is an act to amend the correctional law in relation to adequate staffing at correctional facilities. I will be voting without recommending any negative votes. The bill is referred to Finance. Next, Senate Bill 2042, also to be referred to Finance, sponsored by Senator Hassel Thompson. This was reported out of committee last year as well. It is an act to amend the correction law in relation to increasing access to substance abuse programs for prisoners whose first language is not English. Motion to report. Negative votes. The bill is reported to Finance. Senate Bill 2386A will also be referred to Finance, sponsored by Senator Gianaris. An act to amend the correction law in relation to the registration of sex offenders, and it has to do with the updating, among other things, of updating of photographs on an annual basis as opposed to what it currently is, where it's differentiated between level 3s and then level 1 and 2. This bill did pass the Senate in 2015.
Move the bill.
Second.
Negative votes. Senator Hassel Thompson in the negative. The bill is reported to Finance. Senate Bill 2885, sponsored by Senator Ranzenhofer, an act to amend the correctional law in relation to prohibiting sex offenders who reside in community homes. This passed the Senate in 2015 as well. Any motion?
I just have one question. I know we moved this bill last year, and I support the council, but what if the registered sex offender is also a developmentally disabled who needs to reside in a community home that's run and operated by the Office of Mental Health? Do we have homes for registered sex offenders? We must segregate them if they're also.
No.
They are in group homes.
They are, right, but are they in group homes that only house
No.
sex offenders? So how do
No,
we?
they were. And the state has closed. I'm not aware that they closed all of them. They've closed most of them. And this came about as a result of the state closing, this bill in particular, the state closed a home in the Rochester area that held nothing but sex offenders. It was a secure facility. I forget the acronym. Maybe they call it limited secure. I don't know exactly. But nonetheless, they closed them and without notifying any communities, started placing them in various communities. And the concern was, and I know this has not been specific to some of the facts of what took place, in one particular instance in a community in my district, actually, they were located about 1,500 feet from an elementary school in a group home. In Senator Ranzenhofer's district, there was some similar experience, or basically placement of where the group homes were. And the group homes were not subject to the the residency limits. So I believe that that's the genesis of the bill. I don't know what else the sponsor, had in mind when he did this. There is a problem. I don't know if this is the answer or not. This is in response to the state closing some of those homes.
I understand the
If
problem.
not all.
I But the way the legislation is written, it defines a community residence, and then it goes on to say, any sex offender registered pursuant to this article shall be prohibited from residing in a community residence. A community residence for purposes of this section shall be defined as any facility operated by or subject to licensure by Office of Mental Health or the Office for People with Developmental Disabilities, which provides a supervised residence or residential respite services for individuals with mental disabilities. But what happens if one of those people is also a registered sex offender? Where would they then reside? If you don't also then have a place for people who are entitled to residential services and are sex offenders? That's the question.
We had an instance of this in one of my communities. We had meetings with OPWDD, and the answer was definitely more supervision of that individual. And the community accepted that. And we had community members and the mayor and everyone at the meeting, and went on to, offer a phone number, please call, anything that's called. So as long as they're totally supervised, you don't want to put them all together either.
But see, Betty, you live your communities are very small, and the kind of intimacy of those communities can accommodate that. Some of the larger communities, we don't have that advantage, and I think I'm going to vote for the bill, but
Right.
that is a concern. It's
Yeah.
a very real concern, because again,
I don't think that this
we're
person
trying to
was
figure this.
a violent sexual offender in any way.
I would assume
Something
that.
happened
Or the concern is the agencies that run these facilities, because 80% of these services are provided by the nonprofit world, they will refuse to accept any of the placements, and then go, okay, so where do these individuals go? So I think, I'm going to support it as well, we passed it in the past, but I think we should speak to the sponsor. We might want to amend it to indicate that those who are sex offenders and are otherwise entitled to this service might need additional supervision
And
as
furthermore-
a facility that you can do.
I have a question, because I believe that there's no distinction by levels in this bill either, correct? So that has always been a consistent concern of mine, because there certainly, while level 3 sex offenders are certainly predators, level 1 sex offenders are not. At least I would not consider them, for many of the crimes that they're convicted for level 1 sex offenders. So then you have a developmentally disabled person that has been convicted, and then is a level 1 sex offender while he or she is out, then all of a sudden they have nowhere to live, and not necessarily somebody who's a predator needs to be supervised. So that's why I'm going to vote against it.
multitude of bills to try to protect everyone from sex offenders. I will tell you, I had a nursing home discovered they had a level 2 sex offender patient. She said, we do background checks on everyone that works here. We did not realize we needed to do it on patients, and they don't know who's so they could not get rid of that patient either. Finally, he did something and he went to county jail, and they ended his residency there. And the state went after him. They said, you have to hold his bed until you send him to jail.
OPWD, I had some conversation with them 2 years ago when it took place out west. And part of their response, they say that it was driven by the Olmsted decision, which requires the least restrictive environment and opportunity. And they're very reluctant to recognize that they're registered sex offenders. They look upon them as developmentally disabled, and that will applies, and that comes first, and they are that. And nothing else. And my argument back to them was, yes, they are developmentally disabled. They need services. They're also sex offenders in violation of our laws. And the legislature in years past saw fit that they should be registered. The community should be aware of who's there, and it's a real concern. And it fell upon deaf ears. So it's a legitimate problem. Don't know if this legislation is the right solution for it in the long term, but it addresses some of the problems with it. But there is an existing problem right now without a long-term answer.
And if I recall, this man at that time had never been convicted yet. They called off as long as they had convictions.
In the Senator Rivera's point, the ones again addressing Greater Rochester, Greater Buffalo areas, and intimately about look at the history of someone. Some individuals are extremely dangerous. Some had not even served probation. The result of some of their offenses were things that took place within a group. So they did have the range, and the bill does not differentiate. Right?
And in Tucker Lake, we have these centers for intensive training, and some of those are developmental disabled people with problems, and they are part of the Sundown. And they also have regional behavioral facilities that are secure, as our cities are very secure. For some people, but they can't. Well,
So we had another piece of legislation that I had sponsored that we passed in the Senate last year, and I think we moved to a committee already. And that has to do with, it's a similar circumstance, or a similar set of circumstances, but it requires prior notification to the communities from OPWDD. Oh, okay, so that could, if the was to take place, let people in communities try to prepare in advance. So it would expand the notification beyond just notifying the chief of police, who then notifies the school district. Last year, OPWDD was extremely resistant, saying they focused on them as developmentally disabled individuals, and they're violating those laws. So we understand some legitimate problems. So back to the bill itself, are there any negative votes?
Yep.
Senator Rivera? That bill is reported. Next on the agenda, Senate Bill 3388 will be referred to Finance, sponsored by Senator Lanza. This bill passed the Senate last year as well. An act to amend the executive law.
I'm sorry. I did vote no on well enough.
On the last.
Yes.
So, an act to amend the executive law in relation to the retaking of certain persons absconding from parole or other conditional release. Motion to report. Any negative votes?
Without record.
Senator Rivera without record. The bill will be reported to Finance. Next on the agenda, Senate Bill 3667, sponsored by Senator Savino. An act to amend the executive law and criminal procedure law in relation to enabling victims to view parole hearings via closed-circuit television or a secure online website. This did pass the Senate unanimously last year.
Move the bill.
Second.
Any negative votes? The bill is reported. Next on the agenda, Senate Bill 4153, sponsored by Senator Lavelle. This also passed the Senate last year. An act to amend the correction law in relation to prohibiting certain persons convicted under Article 6C of the correction law from serving as a trustee, principal officer, member of the Board of Education of any public school in any BOCES, city, union-free town, or central school district, or any charter school.
So, I have,
We do have a motion to report to Senator Savino.
here's my concern on this. This is second kind of day, this crime breach. Certainly nobody wants level 3 sex offenders, violent predators on our school boards or participating or teaching children. But we have to remember that it's a very broad definition of sex offenders, particularly the level 1s. So if you're a kid, and here's what I really worry about. All of these kids have these things now. And these cell phones are creating level 1 sex offenders every day. Stupid teenagers take pictures of each other in various stages of undress, and without realizing that they are in possession of child pornography when they do so. And if they get caught, they are automatically prosecuted and become level 1 sex offenders, sometimes level 2 sex offenders. And so if you do something stupid like take pictures of your bare breasts and send it to your 16-year-old boyfriend, both of you would potentially be prevented from ever participating in the school board or any of the things here. So I think we have to be careful about who we're really trying to prevent, and I think realize the age that we're dealing with. We certainly could do better about making sure young people don't inadvertently create problems for themselves. So I'm going to vote without record because I think we need to tighten this. We want to make sure violent sexual predators are not infiltrating our school boards or schools or trying to get access to students or in any way harm children or harm adults that work in the school system. But I think we have to be careful we don't paint with too broad a brush. Because stupid kids do stupid things, and they now have a lot more tools to do stupider things on a daily basis.
Any negative votes?
I just changed mine to, is that right?
It's not right for me too.
Senator Little, Senator Hassel Thompson, Senator Rivera without rec. The bill is reported. We have a number of, when we look at the bills before the committee, well over half of them have to do with sex offenders. And we struggle to not have every meeting be about sex offenders, but it becomes hard to differentiate between the bills and try to select some that might be a little different than others that bring before the committee. This has come up, though, time and time again. So what we will do is we can work on that. We will send out a memo to any of the members that have sex offender. We will send a memo to all of the members, just saying that that issue has been raised time and time again before the committee, and really for their consideration when they're drafting bills and putting things forward. Because I know that it does come up on any of the pieces of legislation where there's no differentiation. I know that it's not.
I mean, there are level 1 sex offenders that prey upon young girls, and they do it repeatedly, and it's statutory rape over and over and over. But they would then be classified as a level 2 or level 3. But there are some,
Yeah. Well,
like you said, it would get into a sexual offense.
the point is well taken. So we'll figure out how to craft it, but we will try to send something to say that at least all the years that I've been involved with this committee, it gets brought up time and time again, just to let others know that it is a consideration of the committee when it comes before them.
It's very interesting, since you came, that seems to be the crumb of the day.
Yeah.
It does, I mean, and you didn't bring this one up with you, obviously. But in the last 5 years, that has been the predominant numbers of criminal. And I think one of the things that we continue to do, regardless as to what the crime theme may be, if you will, to do a knee-jerk. You know, if an incident happens, we think that instantly we have to do something about it. We have to pass a law. And while I appreciate and respect that response, that's not law and justice. That's just, and sometimes I watch us play to the audience. We will bring the families of people, which is very painful. You know, how do we sit there and try to be judicious in our actions with the family sitting there? You know, it's like you're trying to embarrass us into taking a posture that has nothing to do with a rational, thoughtful response. And I just think that many times, I mean, I listened very intently when my colleagues stand on the floor and they defend the bills and they say, well, this happened in my community and the parents are here or the family is here, and I'm like, well, Jesus, come to my community because we be doing crime and correction bills every damn day. You know, and I think that's, we just have to be thoughtful. I think that I'm hopeful that the framework of your letter will speak to that as a part of the issue. Because that's my concern. Yes, we have an obligation to respond, but we have an obligation to respond appropriately and judiciously.
Point noted. The next piece of legislation, I can assure you, was very well thought out. Very well considered.
But I have a question mark at the end. I couldn't figure out how to vote on this, so you got to talk about it.
This is Senate Bill 5978.
Representative Dan Morris.
Yes, I am the sponsor, and it's an act to amend the correction law in relation to enacting what has been named the Prison Privilege Limitation Act. This did arise out of the escape in Dannemora. It's been pared down from what was originally proposed. It was proposed originally, that was proposed first in the Assembly. But it would prohibit specific inmates who have specific convictions those that convicted for murder first and second, aggravated murder, and rape first and second. Prohibits them from being left alone in the company of a civilian, except for the purpose of receiving medical treatment, without the supervision of a correction officer or law enforcement officer. And it also does have to do, it also prohibits for these inmates the wearing of civilian clothing.
No dress down Friday?
Not in the correctional facility. Obviously, when they're attending court, there's a prohibition. So it did spring out of there, and
Thanks for that
I looked at it and pared it down. But I looked at it more. I felt for a long, long time that inmates should not be left alone with a civilian. And the civilian is there for programs and not for security. And we see what took place up there and the problem that can come about with the abuse of something like that. So I look on this more as the safety and security of the facility, and then obviously if somebody escapes, by extension. So that's how that came about. We did move it out of committee last year. Do you have comments?
Well,
Okay, Senator Rivera without rec. Any negative votes?
Yeah, I haven't voted no rules, I see from my history. But I appreciate.
Now that you've gained a better
I said,
understanding.
no, see, you didn't let me finish my sentence, because you're absolutely right. I mean, I needed to have, I put a question mark after it on purpose in the margin to ask you to just tell me your thinking, and I appreciate your thinking. I would be voting yes.
The bill is reported. The last two bills are similar in nature. There are, we've already passed 2 or 3 bills that are similar for other counties. The first one is sponsored by Senator Middle. It's Senate Bill 6-088, an act to amend the correctional law in relation to authorizing the Washington County Correctional Facility to also be used for the detention of persons under arrest being held for arraignment in any court located in the county of Washington.
Washington County is a large rural county, and can't always take the time to bring the person who needs to be arraigned up north. You've got to find a judge that can be there. And so they have the space, and they have the room to have a holding cell, and this would just allow them to have it. I was surprised they had to have legislation to do it, but they do.
Yeah, there are currently 18 other counties where it is authorized.
Does it have to be the arraignment process?
No, they arraign in the morning. Or if there's someone, if it's a reasonable hour and they're nearby, and maybe get the judge, they arraign them then.
I can speak to Albany County, but when this became effective here, instead of calling a judge at 1 or 2 o'clock in the morning, they would transport the individual to the Albany County Jail, call a judge at 6:30 or 7 in the morning, when the DA is available, the defense attorney can be available, the judge can be available, and we bring them out to court.
Because now they have to have a DA as presence.
Was that
No, counsel at arraignment. It
Yes.
facilitates counsel at arraignment.
So this case,
It does, correct.
yeah.
Any negative votes? The bill is reported. Next, a similar bill, Senate Bill 6849, sponsored by Senator Farley. This bill would authorize Fulton County Correctional Facility to do the same thing. Negative votes? The bill is reported. Motion to adjourn. We are adjourned. Thanks, everybody.
A lot of discussion.
Yes.